afternoon. Thank you very much for inviting me today. It's really great to be back in Dublin. My godfather came from Sandy Cove, so when I was younger, I used to come here quite often, so it's lovely to be back. He was not very keen on the European community, as it was called then, but I'm sure he would have mellowed by now. In his honour, his name was Dermot Dunn. I'm really happy to be here. Talking about security and data retention, this is what do they call them? A never-ending story. I'm going to start in 1984 and work inexorably through to 2025. But we basically had 25 years of events and case law and legislation being shaped by those events. So I want to take a high-level view of these cases. Practically any of them, you could spend the whole session on them. But to take you through what's happened and how it has affected the way that European law has developed. Data retention. What does it mean, just so we can kick off? It means the mandatory storage of electronic communications that is not content, which is regarded as a violation of privacy, but the metadata, your traffic data, your location data, where you used your phone, who you telephoned, and so on, where you went online, the places that you visited. Who has to do it? Private operators. It's not done by the public authorities, by the providers of electronic communications. And it's retained for a specific purpose, which is for law enforcement or national security. So the idea is that a law is passed saying you shall, Irish Telecom, hold on to this data for ... months in case the police or national security need it. We talk about data retention, but there's also transmission, where the data is directly transmitted to the authorities, and once it's been retained, access to that data. Now, here is the case law and in fact, it isn't even all the case law, because I've missed one case out now, having spoken to David. But the case law in black is the data retention case law. And as you can see, it started in 2009. The case law in blue is case law on international transfers, where the principles developed on data retention have also played a role, and those cases play a role in turn. And the cases in green, there are 5 of them, are a case law of the Court of Human Rights. Again, you could spend a whole session just on the Court of Human Rights, but I bring those in to enlighten how the EU law system has reacted to that. And it hasn't finished, as you can see. There's even now another pending case. If you look at the date 2014, you see the case Digital Rights Ireland and Zeitlinger. And this is the case that all the other cases flow from. In April, the President of the Court of Justice, Colonel Linitz, said that the cases which are now important are the case law on the balancing between privacy and security triggered by Digital Rights Ireland and Zeitlinger. So that is, as it were, the cornerstone of all this case law. Going back to 1984, by happy chance, this case of an antiques dealer who was nobbled because, in part, of a telephone tapping, had his case heard and decided by the European Court of Human Rights. And what's interesting, this is the first European-level judicial pronouncement on profiling, and it was by the concurring opinion by Judge Louis Petiti, the French judge, and he foresees, and we'll see the same wording coming up 30 years later when we look at Digital Rights Ireland. He foresees the issue. Through use of the mosaic technique, a complete picture can be assembled of the lifestyle of even the model citizen. And he pointed out that at the time, there were 200 to 400 records about each European citizen at the time. Imagine that many, as opposed to the millions that we have now. The first thing that happened that affected legislation and case law was 9/11. The week before 9/11, I was in Parliament, and Parliament wanted the Commission to sue the UK because the UK was a member of the Five Eyes, which was serviced by this wonderful know everything surveillance scheme called Echelon. And we said no, because it was out of scope. And then a week later, you had 9/11, and we forgot about Echelon. It had a direct result, which was the Commission, the European Community, negotiated a scheme with the US whereby the US could oblige airlines to send it PNR data, your flight data. And we got that in place. Parliament weren't happy because they hadn't been involved, and I think they were quite right to be unhappy. And the scheme was struck down in the very first of these cases. And it was struck down because of its legal base. Terrible judgment. It didn't address the issues at all. And it simply said, because the processing is by a private operator, and the transfer is in a framework established by the public authorities that relates to public security. So I want to open the first parenthesis here. This is now gone. There is a difference between what the police and the security authorities do and what private operators do. Article 4, paragraph 2 of the treaty says that national security is the sole responsibility of the member states. But if you look at the e-privacy directive, data protection directive, the GDPR, they all have these two different clauses which have the same words in. One says that state security, criminal law is out of scope, and the other says that you can derogate as a member state for purposes of state security and criminal offences. And the bright line is, if the security authorities are doing it themselves, that is out of scope. But if the data is being processed by a private operator and then taken, that is covered by EU law, and they have to respect the requirements of EU law. So I close my first parenthesis. Second wave, March 2004, you had the terrible Madrid attack. What had happened, the Americans had also asked us to change the e-privacy directive proposal to make data retention compulsory, but it was felt unnecessary. And instead, you had the privacy directive, which is the relevant directive for all this stuff about privacy and data protection in electronic communications. It has these two clauses saying out of scope if it's the authorities, and in scope but derogation if it's private operators collecting the data. March 2004, April, France, Ireland, Spain, and the UK proposed the data retention framework decision, which would have imposed very similar stuff to the data retention directive, which is that data should be retained for a certain period and made available to the authorities. But they did it in what was then known as the third pillar. So the nice thing about doing it this way is you don't have Parliament involved with co-decision, and you don't have to worry about the Court of Justice. The Commission agonized about this. In fact, to be honest, there was a lot of internal disputes and very nasty emails went back and forth. But finally, in February 2005, the Commission announced it was going to produce a directive which would push aside the third pillar instrument. Then you had another attack in July 2005, and the British presidency by December got the data retention directive adopted within 6 months, very fast. And basically it said that you retained traffic data and location data about everybody doing everything on the internet between 6 months and 2 years with no criteria, available to combat serious crime, undefined. And the EDPS, as you can see, characterized it as the most privacy intrusive measure ever adopted by a European level. Also, Ireland was upset about the framework decision having been pushed aside, and it sought to profit from that US PNR case that I mentioned and say the directive has got the wrong legal basis. But the court said, no, it's about what private operators have to do, and therefore it is the right legal basis for the directive. Then things went quiet for a while, and you had the Snowden revelations in June 2013. Let me open another parenthesis, just it's a fun fact, which was until then, the negotiations on the GDPR had been stalled. Certain member states, whom I shall not name for data protection purposes, were blocking it because they had lovely data protection legislation and they didn't want nasty foreign stuff interfering with it. A bit like the Californians blocking the proposed federal privacy legislation in the States. They didn't want federal preemption, reducing the standard of data protection. And in Parliament, people were wandering in, lobbyists with amendments, and the situation was ridiculous. After Snowden, it all changed, and that's when the GDPR became serious, and all these silly amendments were thrown in the bin. It also resulted in these two cases that I'd like to talk about: Digital Rights Ireland and Schrems. What is the criterion for assessing whether an EU law instrument is lawful or not? You look to the Charter of Fundamental Rights, Article 52. There must be, and this is standard European Convention of Human Rights stuff as well. There must be legislation. It must respect the essence of the rights. There must be an objective of general interest. It must be necessary, and it must be proportionate. So this came into issue when the digital rights case was considered. Digital Rights Ireland, a local body with whom you may be familiar, filed with the High Court immediately after the Data Retention Directive was adopted. But it took 6 years for the High Court to actually refer the case. There was loads of challenges and so on. And in the meantime, there was a fuss in Austria as well. And so the two cases were finally lodged with the court in 2012. In some in some countries, the parliamentarians blocked implementation of the directive, like Sweden, which was fined for non-implementation. In other countries, constitutional courts said it was unconstitutional to implement this legislation. And the Court of Justice said it was indeed invalid. It did have an objective of general interest, of course, but it wasn't strictly necessary, and it was outside the principle of proportionality. Covered everybody, no criteria for what is serious crime, no prior review, and this is the theme that keeps coming up over and over again. And we're back to Malone in 1984. Metadata, harvesting of metadata, allows very precise conclusions to be drawn concerning the private lives of the persons concerned. Profiling. And as the court said, there was an interference with the entire population. No exceptions for people like judges, lawyers, doctors, journalists, everybody. So it was chucked out. Let me open another quick parenthesis. They mentioned the issue of freedom of expression, both the Advocate General and the court. And this language is very reminiscent of George Orwell's book, 1984, that if you are being monitored, it can have an effect on the way you behave. We can see that now with the way people do things with their phones just before traveling to certain countries. And the court did not follow it up. But in the subsequent cases, in all of them, the court has stressed that there is a violation of the right of freedom of expression if the surveillance is not being carried out proportionally, as well as the violation of privacy and data protection. Closely following, another immediate, these are all within months, these rulings of the Snowden revelations. This was the first private transfers case. This was Max Schrems, who didn't like Facebook Europe using the safe harbor to transfer his personal data to Facebook Central in the United States. And what was really interesting about this case is that the court didn't just say this was unnecessary or disproportionate. It said it hadn't respected the essence of the rights, that there was nothing there about access to guarantees. So it was compromised the essence of Article 7 of the Charter. There was nothing there that allowed you to pursue a legal remedy, not in the United States, but in the Commission decision setting up the adequacy decision, which was the basis of the safe harbour. Absolutely stunning decision, because this is really, really bad. I was representing the EDPS in that case, and we argued that this should be done, joining the European Parliament and I think it was Digital Rights Ireland themselves. Meantime, look at the dates of these things. October 2015. You had the Court of Human Rights and the Court of Justice in tandem on these criteria. In the Zakharov case in December 2015, Szabo and Vissi against Hungary, fortunately quite easy to pronounce cases. I'm lucky with these. And they both followed the settled case law of the court. And I'm mentioning them now because this is the high watermark, and you'll see a change. Again, shortly afterwards, when the Data Retention Directive was invalidated, then you were back to the e-privacy directive and the possibility for member states to derogate on grounds of criminal law or national security from the rights in that directive. Do this criteria in Tele2Sverige and Watson, do the same criteria apply to national legislation? Yes, the court said. You can't have general and indiscriminate retention, and you have to have an objective of fighting serious crime, not just ordinary crime. And retention should be targeted. Access should be subject to prior review. And I know that you take a particular interest, David, in the interaction between the two courts. And this, for me, is the high water mark of them interacting. Because if you want to know, whoops, pushing the wrong buttons here. If you want to know what these phrases mean, look at the Hungary case. Targeting, you have to demonstrate the real or presumed relationship of the suspect with any terrorist threat. And what's prior review? Well, the best prior review is external judicial control. So these cases are just interacting up to this point. And again, you had another Schrems case and another deal with the US being invalidated by the Court of Justice because it was inadequate. I simply mention it because it's all there in that same time zone. Then continual pressure on the Court of Justice to modify its approach. It's stopping national security doing its job. It's getting in the way of law enforcement. And you had a trio of cases being sent up from France, from Belgium, and from the United Kingdom. That was in the sad, dark days of the last months almost of British membership of the European Union. And they all sent cases to the court. The British court said, hey, have you not noticed that this stuff is all out of scope? And the court said, no, it's in scope, as we've mentioned. And in France and Belgium, the constitutional courts said, are you really sure about your criteria? And this is the first case where commentators have accused the court of trimming its sails. It did, but I don't think it did damage to the basic point. And it added 5 points. So you can't have generalized and indiscriminate retention. It must be for serious crime, but you can have expedited retention, quick freeze of all the data available, which privacy advocates think is wonderful and security say is useless. So I just give you the two opinions. You can have targeted retention, and they gave us a bit more ideas, a few more ideas of what does it mean. It could be categories of persons or geographical criteria. So remember there was the attacks in Brussels and Paris, and it was being organized in a particular area of Brussels called the Marais. And so you could say, right, we take that as the criterion, or an airport, somewhere where there's lots of people and possibly high level of danger. So they brought that in. The main thing they brought in, they said that national security is an objective unlike any other. It is especially important. So you can have general and indiscriminate retention or transmission of traffic and location data if, and I translate this, if there's a clear and present danger, serious threat to national security, genuine and present or foreseeable, for the time necessary and subject to binding judicial review. So this was the first step towards flexibility. Then also the two little points, which we'll see just become big points in a moment, generalized retention of IP addresses to address serious crime is okay as long as you don't reveal the user's identities. There's only 2 lines of that, but we'll see there's been a humongous case taking that up, which I'll talk about in a moment. And then if it's just civil identity data, your name, your address, your email, your phone, that's okay, because it doesn't affect, it doesn't give you any other information. It doesn't reveal your private life, your predilections, your political views, whatever. It's just a fact. So it's okay for any purposes to have generalized indiscriminate retention of that. Now, that case was decided, let me get the date right again, in the 6th of October 2020. The hearing in these 2 cases in Strasbourg was in 2019, Big Brother Watch and Centrum för, the Swedish case. And they waited. They waited past the hearing of the Court of Justice, and they waited another year, because you look at the date, 25th of May 2021. And at the time, I was a bit puzzled, because they simply said, time to change. Bulk interception, by the way, which is the new way of calling surveillance, mass surveillance, is okay as long as it's got sufficient safeguards. There's been a global assessment, so a holistic approach, everything taken together is okay. And specifically, the end-to-end safeguards are there. Assessment of each stage, independent authorization, supervision, and ex post facto review. And they applied that in the Centrum för rättvisa and Swedish case. And they said, well, generally, it's okay for the global assessment, but there were 3 specific safeguards which were missing, things like prior judicial review. So they said that was a violation of Article 8 of the European Convention of Human Rights. But I didn't understand it at the time. And then last year, I heard Robert Spano, who was the president of the court at the time, saying, we decided we had to send Luxembourg a message. And the message is bulk interception. It's time to admit that generalized and indiscriminate retention is okay as long as the safeguards are in place. So 2 different approaches. Anyway, we've got all this case law. You would have thought we'd have enough by now, but we had this huge case decided about a year ago, and David was an advocate in this, so I stand ready to be corrected. France had set up under Sarkozy this 3 strikes and you're out system. Firstly, people representing copyright organizations, IP organizations, can harvest the data of people uploading films onto peer-to-peer networks. Second, they go to this French authority called the Hadopi, and they give that information to the Hadopi, and the Hadopi turns to the French electronic communications provider and says, please, would you match that with the civil identity data? Give us the name and address and so on of the person who was using that IP address at that time. And then Hadopi uses that to send a warning letter, a recommandation, to the hacker. And you get 3 chances. You get the first letter, and if you're caught again, you get a second letter. And the third time, Hadopi considers prosecution. And this isn't actually the whole population of France. It isn't even all the people using peer-to-peer networks. It's the people uploading, but still a sizable amount of people, 83,000 warnings in 2019. So what does generalized mean? Is it the whole population or is it something less? And in this case is quite extraordinary. The Advocate General said it's time to nuance its approach and permit limited data retention, creating with regard to ordinary crimes. He said this is actually the only way on the internet of locating these people. And if you accept that it's a crime, it's the only way of enforcing this crime. The EDPS intervened and said, we think the Advocate General is right. So you had at least one data protection authority which thought, yes. And I say it wasn't everybody, but an awful lot of people. So what happened? The court organized a second hearing. And instead of it being a mere 15 judges in the general court, in the Grand Chamber, it was, well, in fact, they weren't all there. There were two missing. I counted their names. There were 25 of them. There were two registrars and an Advocate General, and David, of course, sitting in the audience. What did it look like?
It was quite the spectacle, because there was lots of people in the audience. There wasn't enough seats for all the lawyers anyway, that's for sure.
And I believe at coffee you said that when the judges came in, they found there were a seat short.
I think there was
as well.
A seat short, but that was quickly rectified, so everybody had a spot.
Incredible. This just not happened before. And the court basically agreed with the Advocate General. They said you can have general and indiscriminate retention of IP addresses so long as it doesn't constitute a serious interference. Well, up to now we've said it's a serious interference if you have generalized and indiscriminate, but it doesn't. And now some commentators are accusing them of legislating, but they said the safeguards you have to have in place are a watertight system, a genuinely watertight system, using a reliable computer system. So Chinese walls, you have to make sure that the only thing that Hadopi are doing is putting IP address and the civil data, the civil identity data together and sending their letter. Because the court said as long as all you know about somebody is they did that uploading, you can't draw conclusions about their private life in most cases, because uploaders are also downloaders or seeders. I have no idea what this means, but the EDPS said that because people are allowed to download if they upload, so they could be uploading anything. It doesn't necessarily indicate what they actually enjoy watching. But there may be cases, the court said, atypical cases, where it could indicate people's preferences. And in that situation only, you have to have prior review by a court or an independent administrative body. And they made this difference because when you're talking about how many cases were there? 83,000 cases. To have prior review of sending the letter in so many cases is just impossible. So it's only in cases which have been identified as atypical. So here you have a case which is, has the court gone back on its case law, or has it narrowed its appreciation for this very specific case? I'll leave you with that question while I talk about the last case. And this is the Court of Human Rights back in full throttle, Big Brother watch, and Sweden well, they don't set it aside, but we're back to the good stuff that they did for all these years. This was a Telegram user in Russia who didn't want his messages to be decrypted, and we know very clearly why. And the trouble is that the Telegram themselves said, if we make it possible to decrypt for him or her, it's possible for criminals to do it too. And it opens a back door. It weakens the encryption mechanism for everybody, both law enforcement and malicious actors. Now look at this wording in their judgment. We're right back to interaction between the two courts. Generalized access without sufficient safeguards impairs the very essence of the right to private life. We're right back to that very case, very first case. This is fighting talk. And why is it really interesting? Because you now have all these EU and national initiatives saying you have to decrypt. You have legislation in the UK, in the United States. The EU has a proposal, CSAM, for protecting, so-called protecting children, requiring decryption of communications. And here you have the Court of Human Rights saying, do not tamper with decryption, encryption, because you just open you open more problems than it solves. So where are we with that? I think we're still in a situation where law enforcement and national security have to think about what they're doing. They have to think, are the safeguards in place? Are we justified? And there are situations where you can have generalized, you can have very wide retention of data. But I still think the Court of Justice is holding the line, but it's doing it in a way that doesn't upset the national courts. In Hadopi, there would have been a huge problem with France and with the French Conseil d'État. I have no doubt about it. After LQDN, when it went back, La Quadrature du Net, went back to France, the Conseil d'État said, we are responsible for the law in France, not them. So they denied the concept of supremacy in community law. They didn't do what the French government wanted, which was to say that the Court of Justice's opinion was ultra vires, which is what the German Constitutional Court said in Weiss. But they said, well, okay, applying the judgment, yeah, every year or so, the French government should just check and make sure that there's still a situation of extreme danger going on. So the court is treading this line of holding the principles, but doing it in a way when it is not going to have, not going to create a backlash with its fellow courts at national level. So I'll leave you with that thought.